There we go. Right. So it's with absolute pleasure that I introduce Alice Rowe, who has very kindly agreed to speak to us today. I first saw Alice, I think you spoke to it was either an ADAS or an LGA event, and I watched your webinar, which talked about this research, and I was just hanging off every word, and I thought, oh, the advocates have to know about this research, because it feels to me, working in advocacy, that it's a group who are really deprived of liberty and have a lot of restrictions applied to them, but as advocates, doesn't feel like we always know the system around them. So that was kind of my motivation in inviting Alice. So Alice is a researcher from the Nuffield Family Justice Observatory, and she's going to talk to us today about some research that they have recently published to help us understand. Alice, welcome.
Great, thanks, Kate. It's lovely to be with you all this afternoon. I'm just gonna share my screen, so hopefully you can see that. Great. It's lovely to be here. As Kate said, I'm Alice Rowe. I'm a researcher at the Nuffield Family Justice Observatory, and I lead our programme of research about children and young people in the care system who are being deprived of their liberty. So today I'm going to focus really on some research that we've been doing over the last few years, particularly our work looking at applications which came into the National Deprivation of Liberty Court when it ran throughout its pilot phase over 12 months. And sharing a bit about what we learned from that about children who were subject to deprivation of liberty orders under the inherent jurisdiction of the High Court. So before I go into that, just a brief introduction to the Family Justice Observatory for those of you who don't know us. So the observatory is funded by the Nuffield Foundation. We've been going for about 4 or 5 years now, so we're still a relatively new organisation. But our ambition really is to improve the lives of children and families that come into contact with the family justice system by increasing the use of research and evidence in that system. There's a little bit of interference. I don't know if you could just all put yourselves on while I'm talking. Thank you. So we're not just a research organisation, although we do a lot of research. We work a lot with data and publish reports. We don't see that as the end of the process, and a lot of our work is focused on what we can do with that evidence and how.
Alice, I'm so sorry. I've just muted you on accident. I'm trying to mute other people.
Sorry.
I'll just try to see it. I've still got it. We're still in there. I've got my slate.
There's still a little bit of interference. That's better now. Great. I'll carry on. So we try and use data and research to promote discussion and to bring together different groups of professionals that are working in the family justice system to facilitate change for the benefit of children and families. So that's very much the kind of lens with which we approach our work on young people in the care system and those at risk of or being deprived of their liberty. So what I'm kind of talking about today, focusing on the research and developing the evidence base, is really just the start of our work and the process we hope to take in this area. So as I mentioned, the research that I'm going to be talking about today mostly uses data that we collected from the National Deprivation of Liberty Court. So this was set up by the president of the Family Division in July 2022 with the aim of really kind of centralising the process for local authorities or other applicants applying for a deprivation of liberty order under the inherent jurisdiction. So in the 12-month pilot phase, all applications to deprive a child of their liberty under the inherent jurisdiction came centrally to the Royal Courts of Justice and were heard by a group of specialist judges there. This meant that really for the first time we were able to do some research on these cases Before this, we didn't even really have consistent data about how many children were subject to DOL applications. This information wasn't collected by any government departments. So we at the Family Justice Observatory were really privileged to be invited by the President to start to collect data at the DOL court and to publish what we found. So just a note also to say, some of you may know this, but the DOL court, as it was in its kind of 12-month pilot phase, has now finished. We're no longer doing this research, but it's moved on into what's called the National DOLS list. And this means that applications are still sent centrally to the RCJ, but are then kind of filtered out, and with many more applications going back to be heard from the local courts and local judges there.
Alice,
yeah.
it's Kate. Just before you move on, we've had a question that feels relevant to that slide.
Yeah.
Could you quickly explain what inherent jurisdiction is?
Yes, of course. So the best way to do that is, so here we're talking about children being deprived of their liberty. So this is under 18-year-olds, and there are multiple different routes that an under 18-year-old can be deprived of their liberty. This can be under the Mental Health Act. It can be a secure accommodation order that's made by the family courts under the Children Act. Or a child can be sentenced to youth custody or remand and sent to a custodial secure placement. The inherent jurisdiction kind of sits outside of these three statutory routes, and it's a kind of special order that can be made by the High Court, so only by High Court judges, to deprive a child of their liberty. So it sits outside the Children's Act, but is intended really to be used as a last resort when those other statutory mechanisms don't apply. But as we'll see, is being used kind of much more often than it really was intended to be used. So hopefully that covers that. It's applied for children, so those under 18 who are in the care of the local authority. So talking here specifically about children in the care system as well. So moving on then, before I go into the data and the facts and the figures, I wanted to start with a case study. And this is a fictionalized case study, but is very kind of shows really very similar to the cases that we saw while we were doing our research. And I'm sure for those of you who might be familiar with children subject to deprivation of liberty orders, will be a kind of a familiar story. So this is Shane. Shane is 15. He was removed from his birth parents as a baby and adopted when he was 1 year old. Concerns about his behaviours started to escalate when he was 8, following an incident that led to him being temporarily excluded from school. His adoptive parents increasingly struggled with his behaviour, and he eventually came into care when he was 11. In the last 4 years, he's lived in 8 different places, including 2 placements with different foster carers and 6 different residential placements. He can be verbally and physically aggressive, has assaulted staff and caused damage to property. He has self-harmed, taken overdoses of medication, and has said he wants to kill himself. He smokes cannabis and drinks alcohol. He's also been out of education for 6 months. Although Shane does not have any formal diagnoses, the local authority are seeking a reassessment for ADHD. He was initially settled for several months in one placement with a deprivation of liberty order in force until an incident when he attacked staff and set fire to furniture, at which point the placement gave notice. The local authority has since struggled to find a new placement for Shane and is proposing to place him in a rental flat under a deprivation of liberty order while it continues to search for a registered placement. The restrictions sought are 3-to-1 adult supervision, the removal of items that he could use to harm himself, constant monitoring throughout the night, and for doors and windows to be locked. He will not be permitted to leave the placement, and physical restraint will be used as a last resort if he tries to. He will be looked after by carers from an agency who he has never met before. So Shane is just one in over 1,200 children who have been subject to applications to deprive them of their liberty in the last year. So in the 12 months where we were doing our research at the Dole Court from July 2022 to June 23, there were over 1,300 applications relating to 1,249 individual children. And as you can see from the figure, this remained kind of fairly consistent month by month. So we know now that far more children are subject to deprivation of liberty applications under the inherent jurisdiction than secure accommodation applications. So between July 2022 and March 23, there were almost 10 times as many applications under the inherent jurisdiction for deprivation of liberty orders than there were applications for secure accommodation orders to place children in a registered and regulated secure children's home. So it's really clear from this that the regulated secure accommodation that we have is not able to meet the needs or the number of children that are deemed to be needed to be deprived of their liberty for their welfare. And the use of deprivation of liberty orders is a nationwide problem, although there are some patterns of regional differences. So over the 12 months, almost all local authorities in England and slightly less in Wales made applications to the Dole Court to deprive at least one child of their liberty. Although there are some regions that seem to be using these orders more than others. So for instance, the Northwest had the highest rate of applications. So 40 deprivation of liberty applications per 100,000 children in care in the Northwest of England, with rates also quite high in London. And there might be multiple reasons for this. It might relate to practices in the local authority around when it's appropriate to apply to the court for authorisation for a child's care plan. But it may also relate to factors about the needs of children in those areas and the availability of provision in these different areas as well. So then moving on to what we found out about the children who are subject of these applications. Most children are slightly older, most aged 15 or over, but there is nonetheless a significant minority of children that are aged under 13. And it's important to stress here that under the statutory scheme to place a child in a secure children's home to make a secure accommodation order, children under 13, those applications have to go to the Secretary of State and to be approved by them. So there's that extra kind of safeguard there for younger children for secure accommodation orders that doesn't apply to children subject to DOLS applications. And then we also know that boys and girls tend to be affected equally, and so a relatively equal number of boys and girls subject to these applications. But we don't, unfortunately, have good data relating to the ethnicity of children subject to deprivation of liberty applications. And this is because it's unfortunately not required on the application forms to court. So when we were going through the application forms, going through the case files to do our research, this information was missing in almost half of cases. And we were reliant on the local authority including it themselves in their evidence statement, rather than it being something that was required by the court to make the application, as for instance, the child's age and gender was. So where data was available in those 55% or so of cases, it was suggested that children from mixed and Black ethnic groups were overrepresented compared to children in the general population, and children from mixed ethnic backgrounds were also overrepresented compared to the children in care population. So were more likely to be subject to a deprivation of liberty applications than other children from different ethnic groups. So we need to do much more research in this area to understand whether this data that we have that's a snapshot is representative of what's going on, and also to understand any differences in the journeys of children from different ethnic groups through this system. So in terms of,
Sorry, it's Kate again. Another question that was relevant to the slides. Christine's asked, are the stats for the inherent jurisdiction DOLS, or do they include applications to the Court of Protection for 16 and 17 who are mental capacity?
These are all inherent jurisdiction only. So applications for deprivation of liberty orders under the inherent jurisdiction. So nothing it's a good question, but none of the data I talk about today will relate to the Court of Protection. It's only those High Court Family Division cases that we're focused on today. So moving on then to what we know about the experiences and needs of children subject to these applications. So the next few slides are based on an in-depth case file review we did of 208 applications that were made in July and August 2022. So this was looking kind of beyond the information that came just in the application form, but to understand what children's needs were and why the local authority was applying for a deprivation of liberty order. So we found then that children are well known to services. Almost all of the children in the cohort were already in care at the time of the deprivation of liberty application, and the vast majority had had long-term involvement with children's social care throughout their lives. So these aren't children whose needs kind of suddenly escalate and they suddenly appear to services. They're well known to services for many years. So only 10 children and their families in our cohort had recently come to the attention of the local authority. And in the years before the application was made, children experienced frequent disruption and instability. Over half of children had experienced the breakdown of multiple placements, and some had moved as many as 10 times in the period leading up to the application. We also saw that the breakdown in family arrangements was relatively common in the lead up to a DOL application being made. So 19 children of the 208 had experienced the breakdown of adoption or special guardianship arrangements. And as well, within this cohort, there was frequent exposure to childhood adversity and trauma. So children being experiencing kind of ongoing issues in the family home that may have led to some of the behaviours and risk factors that led to them being subject to a deprivation of liberty application. So at the time of the application, then children tended to have multiple and complex needs and experiencing complex circumstances. And the application was often made at a time of crisis for the child, when the risk of serious harm to the child as a result of their behaviours or external risk factors was considered so immediate and severe that the only option the local authority felt they had was to apply to the court to deprive the child of their liberty in order to keep them safe. So in almost all cases, the vast majority of cases, children were facing multiple issues that led to the application being issued. So it's not the case that these children have a kind of single issue that is particularly severe, for instance, just self-harm, but there will often be multiple issues and needs going on for that child. That is some of what can make these cases so complex, and the need to address these different needs at the same time. So for instance, common issues that were mentioned in the applications were concerns about the child's behaviour that was considered a risk to others, mental health or emotional difficulties, and this included diagnosed mental health conditions, but also concerns that there were underlying emotional difficulties or mental health concerns that hadn't yet been diagnosed. Self-harm was very common in the cohort in over half of cases. About a third had a physical or learning disability, and about a third as well were considered to be at risk of criminal or sexual exploitation. And a quarter as well had a diagnosis of autism spectrum disorder. So quite high cross-cutting needs within this cohort of children subject to DOL applications. So in our research then, we tried to see if we could identify different groups of children. So to understand within this kind of 1,200 children who are subject to DOL applications, are they all experiencing the same needs? Or are there kind of different groups within that? And the reason why we wanted to ask this question was to try and help think about what type of provision might be needed for these children. So often they're subject to a DOL application because there's no other placement available for them. So we felt that better understanding what their needs were can help us think about the type of provision that they might need going forward. So we identified three kind of broadly different groups of children. Although it's important to stress that this isn't a kind of neat distinction, there is of course crossover between these three groups, and also to stress that the level of need and risk faced by children in each of these groups was very extreme and severe in a lot of cases. So the first group that we identified were children with learning and physical disabilities, where the deprivation of liberty order was sought primarily for reasons relating to support or supervision for that child as a result of their learning or physical disability. And this was in approximately a quarter of all cases. So these children tended to be in slightly more stable placements than the other two groups, were more likely to be placed in a registered placement. But their needs meant that they were likely to be subject to a deprivation of liberty order for a significant period of time, often for many years. And it was also deemed likely that the nature of their needs meant that their case may transfer to the Court of Protection, as well as to adult social services. The second group then was around half of all cases, and this was children who had multiple complex needs, often recognised to be a response to complex and ongoing trauma. So this was the cohort of children where there was really this, we saw this real kind of multiplicity of need and a level of complexity that meant that traditional placements for children in care just weren't suitable for this cohort. And they needed a level of support that often wasn't available. And then the third group, which was around a quarter of all cases, was children where a deprivation of liberty order was sought primarily due to external risk factors. So the child's risk of sexual or criminal exploitation, for example. So although there was a kind of crossover between groups 2 and 3 here, this last group, it was really their risk from exploitation that meant that they were at severe risk and was the reason why the local authority was applying for the deprivation of liberty order at this point in time. But that's not to say that some of the issues in the second group around self-harm, mental health, and so on weren't also apparent in this group here. So we also tried to understand a bit about what happens to children once a DOL application is made. So in order to do this, we tried to follow as many of the 200 cases that we looked at in the first case file analysis for around 6 months, and to look at the legal orders that were made in these cases. So in the end, we followed 113 cases that were issued in July and August for approximately 6 months. And we found the deprivation of liberty orders tend not to be short-term measures. So over 2/3 of the children were still subject to a deprivation of liberty order 6 months later. And in this time, the restrictions that they were placed under were really quite severe. Each child was subject to an average of 6 different types of restrictions, including in almost all cases, constant supervision, often at a rate of 3-to-1, 4-to-1 adults, constantly being supervising the child. The use of restraint was also permitted in over 2/3 of cases. And crucially, when we followed these cases longer term, we saw that these restrictions were rarely relaxed over that 6-month period, which suggests to us that these orders and these kind of restrictive environments that these children are being placed in are not really doing much to lessen the level of risk that each child is experiencing. Ideally, we'd want to see the level of restriction come down in relatively quick succession if the restrictions were supporting the child to get the help that they needed. So we also looked at where children were placed, particularly focusing on whether they were in an unregistered or a registered placement, so a placement that was registered and inspected by Ofsted. And over half of children in this 113 cases that we looked at were placed in at least one unregistered placement. So this, again, is a really high number of children being placed in what were often kind of really unsuitable placements for some length of time. So this included quite commonly things like Airbnbs, rental properties that were rented by the local authority for that child specifically, but also included kind of holiday lets, canal boats, really places that you wouldn't want children to be placed in for any length of time. And often these placements were also quite far from the child's home. So the average distance in our study that children were placed was 56.3 miles. So I want to move on now to talk a little bit about children's opportunities to be involved in these proceedings and to be involved in their care plans when they're at risk of being deprived of their liberty. So when we were looking at the legal orders, we also tried to look at whether children had been able to participate in their proceedings. And we found that the level of participation was really, really quite low. So just 10 children had attended at least one hearing in their case. Just 5 had the opportunity to speak to the judge directly before the hearing, and 6 had written to the judge to share their views about what was happening to them. And we would really want this to be much higher, although these are children that are experiencing often kind of crisis points. They tend to be older, and they've been in the system for a long time. And we really think that the local authority should be trying much harder to support them to be involved in their proceedings in whichever way they can. Of course, most children will have a guardian appointed for them in the proceedings. But we also found some issues with how this was working. So in the inherent jurisdiction, the child has to be made a party to a proceeding before a guardian can be appointed. This usually happens automatically when the application is made, but we saw some delays to that happening. So for instance, applications coming in that were urgent had to be heard within the first 24 hours, and an order being made without a guardian being appointed for that child. And then also some concerns about guardians' ability to meet with children, to visit the placements that they were in over the long term, to really understand the child's needs and the kind of support that they should be getting. Alongside this, we also found that parents and carers have very limited opportunity to participate in deprivation of liberty proceedings. And in the vast majority of cases, parents or carers were not legally represented at any hearing. And some of you may have seen that Family Rights Group now have a campaign ongoing to try and increase the amount of legal representation that's available to parents for deprivation of liberty proceedings, given the extent of kind of intervention that's being suggested to the court in these cases. So now I'm going to talk a little bit about the research I've spoke about so far. It's focused on what we've learned from case files about children, about their cases, and about what happens to them. I'm now going to include some quotes from children and young people about what they've told us about what being on a deprivation of liberty order is like, and their experience of the system when that is happening to them. So the first quote here reflects on being placed far away from home and how that felt for this child. So she said, "I've been placed far from my family, and I feel once you're in the care system, they aren't there to help the families and keep them together. For 3 years, I spoke to hardly no one because I knew no one, as I was being moved constantly." And then the second two quotes here focus on children's experiences of getting the care that they might need when they're at risk of or being subject to a deprivation of liberty order, where there's often this focus on risk, on keeping the child safe, on essentially depriving them of their liberty so they can't do harm, but without really thinking about the kind of care they might need to help them to get better. So one girl said, "Yes, there is a lot of focus on the risks, but not what support I need and how to manage the risks." Another said it was kind of like everyone running around like headless chickens, not talking to each other, not figuring out how to get to a better point. So young people also tell us that they don't feel that they have the opportunity to have their voices heard, or that decisions are made without involving them. So one boy said, "I haven't been too much involved with decisions about me. I will be told the decision after it's been made, and I won't have a choice on it." And another girl said, "When I am low risk, I'm involved well. When I am high risk, I'm not involved in as much." And initially, I didn't know I was getting a deprivation of liberty order. I found out I had a DOLS once it was in place. Once I found out, I had to chase to be allowed to be involved. Once I got the details from my guardian and solicitor, I was able to involve myself, but I did not have any support to do this. So I'm going to try and play the recording of this quote if I can. So hopefully you'll be able to hear it. If not, just you can.
I was not made aware I had a doll until 6 months after the order was put in place. So I wanted to go about life as you would normally do as a teenager. I would go into school with my friends, and then I was taken into a private room, secluded from everywhere else. I had to be escorted from the car by my carers to staff in school, and then escorted from staff in school to the car with my carers. I was in private room from the hours of 8:45 till 3:05 the entire school day. I was not allowed to go out for break or lunch. I had to put in my lunch order with staff. I was not allowed to talk to my family or anything, and at the time I had no reason why.
Again, this child, without being told what was happening to them, without understanding the reasons for what was going on in their life, felt like they were being punished rather than being helped by the local authority.
I was not made aware I had a doll.
So to summarize then, we know that deprivation of liberty orders are quite an extreme interventions into a young person's life, often made at a time of crisis for that child when the risks that they're experiencing are very severe. And their behaviours and poor mental health that might lead to the deprivation of liberty order being made are often the result of early and ongoing complex trauma and sustained adversity that they experience. And the systems of social care, health, education, and other systems responsible for these children are really failing to respond to their needs at an earlier stage in their lives, and also throughout adolescence when their needs start to escalate. And we talk quite a lot here about siloed systems, so different systems with different legal frameworks working in different ways that are not joining up adequately to meet the needs of these children. And this is often because there's a little incentive for different systems to work together. Costs, for instance, between social care and mental health aren't shared. And we've seen examples of different services trying to kind of fight over children, say this child's not my responsibility, it's your responsibility, and really not working together to support that child and to give them the care that they might need. We've seen that young people have very little agency over what happens to them, and families are often not involved to the extent that they could be. They may be seen as part of the problem rather than part of the solution. So we know that professionals tend to turn to secure accommodation or to deprivation of liberty orders as a last-ditch response. And this is really because we don't have the provision, or there's too limited provision to meet the needs of this group of young people, sorry. And in the absence of this alternative provision, young people are placed in settings under deprivation of liberty orders that are often really patently unsuitable for these children. And the reason why we've kind of ended up in this situation is we seem to be focused on managing crises rather than thinking about long-term needs and how we might address this for these children. So what we've seen through our research is that in order to better meet the needs of children who are subject to deprivation of liberty orders or who may be at risk of deprivation of liberty orders, significant changes are required to ways of working, as well as to the type, availability and provision of services for these children. So in order to try and support that change and to encourage people from different systems, services around the table, we've developed what we've called 5 principles of care, which were developed in collaboration with a panel of experts with expertise in caring for children who've experienced complex needs and complex trauma. And these principles intend to set out at quite a high level, at a kind of cross-system level, what this group of children need. So the 5 principles are 1, to have stable, valued and trusted relationships, to experience holistic assessment, formulation and a tailored plan of intervention for each child, to have long-term support, to be cared for by highly experienced multidisciplinary teams, and for young people to experience agency and respect. So I'm not going to go into this now, but we'll let you kind of look at this in your own time if it's of interest. But these principles of care are really the exact opposite of what many children are currently experiencing in the system. So often disrupted temporary relationships, experiencing repeat assessments from social services, from mental health care that aren't kind of brought together, experiencing crisis interventions, as I've talked about, and being cared for often by agency staff who may be inexperienced in caring for children with this level of need. And children, as we've seen from the quotes, having limited agency in their day-to-day lives and the decisions that are made about them. So that's been a kind of whistle-stop tour of our research. I wanted to focus now on what some kind of suggestions, some thoughts about what you as advocates might want to do or might be able to do in this area. I really open this up for discussion. It'd be great to hear your thoughts too. But I think particularly focusing on that lack of voice that children experience when they're in this situation. To support children to have a voice and to support their involvement in care planning and decision making. So for instance, making sure that if a deprivation of liberty order might be being considered by the local authority, does the young person know that it might be in place? And one of the things we also saw in the kind of good cases that we saw in the deprivation of liberty court was whether or not there was an exit plan in place. So has it really been thought about how long the child's going to be subject to these restrictions? what needs to change in terms of their behaviour in order to facilitate a reduction in the restrictions, and has a child been brought on board to kind of understand this plan and to understand what's expected of them, what they can expect from services and from their carers in order to facilitate a reduction in the level of restrictions that they're placed under. And we also hope that the principles of care might kind of support a structure for thinking about the care for children in these situations. So are they getting the support and services they need? Is the support they're getting meeting these principles of care? So I'm going to stop there, and hopefully we can answer some questions, have a bit of a discussion. But just to end with some of the references, the links to the research that I've talked about today. You can also kind of keep in touch with our research, the work we're doing in this area, by signing up to our bulletin. There's also a contact email address there if you want to follow up after this webinar. But I'll stop sharing my screen now and answer any questions.
Thank you, Alice. I mean, I don't know how people felt, but it's so sobering listening to those statistics and the experiences of children. It feels like advocacy is completely missing, doesn't it, in so many of these children's lives. Right, there are lots of questions in the chat box, and I think there's a lot of people who want to ask questions. Just to try and make sure everyone gets a fair kind of 2 minutes, could you limit questions to 1, if that's okay? And we'll just go with hands up. So if you want to ask a question, hands up. So Emma, would you like to go first?
Hello, is that me? I'm the only Emma. Is it me, Kate? Yeah.
Go for it.
Great. It wasn't actually a question. It was more of a contribution, a commentary, quick commentary. My research on parent carers and vulnerable adults and children, and the advocacy that I still do, time and time again, part of the issue is it is systemic. It is about power. Power is at the heart of this, and that's something that advocacy plays a role in. The professionals that children and families deal with have a lot of unchecked power in a very, very frightening system. Until we dismantle that or rearrange it in some way, you are not going to change it, because there is a lack of accountability that means that all of these professionals can pretty much act as they wish to, unchallenged, and even an advocate, a single advocate, can make a difference. But on our own, we too can find ourselves disempowered at times, as I know. So there has to be structural changes. I think that's what I wanted to contribute. That's it, Kate.
Thanks, Emma. Lynn, lovely to see you.
Nice to see you. I'll step back and let others have a word now.
Thanks, Emma.
Did you
Go
say?
for it, Lynn. Yeah, it's really nice. Yeah, glad you're here.
Yeah, I was a case I was involved in recently, and I put it in the chat. I was told that there had to be a report from something regulation visitor. I can't remember offhand what it was. I should have checked, but they've delayed going to court because they haven't got anybody to do this. So I wonder if Alice knows more what this person is, what this regulation is.
I'm afraid I don't for that kind of specific case. We see in these cases going to court that there's often issues around the registration of the placement that the child is in. But as far as I know, there's very little kind of oversight of the places that children actually end up in. So one of the things the court will continuously say is to try and chase the process for registering a placement with Ofsted, but that often doesn't happen. And then, yeah, it really feels like there's not enough oversight of where children are being placed, who is looking after them, and what they're kind of doing on a day-to-day basis. That doesn't quite answer your question, but
it is an unregulated placement. I don't think it was a Reg 44 visitor at all. It was. I will check it out, and perhaps I'll get back to Kate to say what it was. But it was something I hadn't come across, and I was a bit flummoxed. But thanks.
Sometimes, Lynn, I don't know about you, but sometimes I feel like I'm just fobbed off with excuses sometimes, and it's like you've got to get your bullshit sniffer out. because I think sometimes they just yeah, try and blag the way through. So you've got to be really on it, haven't you? You also put in the chat box, Lynn, a really good question around 2-to-1. And Alistair, if you have a view on this, there's kind of a few myths I think around, oh, you can only be on 2-to-1 or you can only be on 3-to-1 if you have a DOLS. I don't think that's strictly true, because it depends on so much, doesn't it? Like the child's age, the competency, the restrictions. Are you coming across that, Alice, like blanket kind of quite crass? If
I
this
think
happens, you've got to have a DOLS. Yeah, sorry.
I think it's a really complicated area in terms of the legislation. I'm not a lawyer, I'm not an expert in the law at all. But I think something we did see in our research was, although most cases tend to be at the kind of higher end of restrictions, so it wasn't just that kind of 2-to-1 supervision, it was often that accompanied by authorization to use restraint, authorization to prevent the child from leaving the placement, and so on. There was quite a wide variety in the types of restrictions that were being applied for. And at the beginning of our research, there was a judgment about restrictions for mobile phone use. So quite often these orders will include restrictions around children's ability to use their mobile phone, to use social media, who they can contact. And that judgment then said that this didn't constitute a deprivation of liberty order, and kind of wouldn't be authorised by the court under a deprivation of liberty order. But I think it's a complex area, and I think there's often kind of local variation in what local authorities will use to apply for a deprivation of liberty order as that threshold, as I kind of mentioned when we talk about that regional variation. So I think that's something that there needs to be more guidance on, because I think it is kind of a mixed picture across the country.
And just before I invite Caitlin, you know, as an advocate, if you feel that something isn't right, you must pursue it. You know, never leave that. If you feel it isn't right, if you feel, you know, we call it the eyebrows test. If your eyebrows disappear above your head because it doesn't feel right, take action. You get legal advice. You ask those pointed questions. It's really on us, you know, to be curious and to dig into that. So encourage that feisty digging into it. Caitlin.
Hi, yeah, I just wanted to ask, I've got a case at the moment where I've got a young person and I feel like the social worker and the team manager are fobbing me off, because the social worker told me many weeks ago that a DOLS order was in place. And I thought, okay, fine. But then several weeks later, I hear they're going to court about the DOLS order. So I don't know what this, I'm fairly new to DOLS. What are the steps from making the application to actually granting it? How many hearings are expected in a DOLS order?
So again, it can vary, but what we tend to see is where a DOLS order isn't already in place and the local authority feel that the care regime for that child constitutes deprivation of liberty or will constitute deprivation of liberty, the application tends to be made quite quickly with a relatively high level of urgency. And the court should be hearing those applications fairly quickly. And usually an order is made if the court agrees that the child is being deprived of their liberty and that is in their best interests. Usually we see a kind of short-term order being made for 5-7 days or so, and then the case might return to court for kind of further discussion, but those orders tend to be made quite quickly.
Okay.
So, yeah.
So you can get like, so she may have been referring to a short-term order being in place and then gone back to court for a longer term order. Okay.
Yes, yeah, possibly, yeah.
Interestingly enough, and not surprisingly to anyone, I should think, I requested and sent paperwork to allow me to attend with the young person at her request, and I got nothing back. No paperwork returned, nothing, no email at all. So that young person, no fault of my own, obviously, hasn't had the advocacy. And actually, the judge said in the first hearing, I want to see your advocate at the next hearing. And that didn't happen. So you know, going back to what other people are saying about it being systemic and people having more power than perhaps they are entitled to, or just, I feel like I've been a little bit brushed aside. Like, well, that's the advocate. We don't need her, and actually, we don't want her interfering in this case. I'm sure that's not a surprise to anyone, really. Thank you.
Good luck, Caitlin.
Thank you.
You're going to need your big pants on with this one.
I am. I've got big pants. Yeah.
Big pants. Yeah. Emma, welcome.
So am I the right Emma? There's a few Emmas, I
Yeah.
think.
Go for it.
So I asked a question in the chat about how much we're seeing local authorities trying to authorise things through the inherent jurisdiction that they should be trying to authorise through the Court of Protection. And the reason I'm asking this is because I have a specialist advocate role where other advocates will come to me and ask about sort of help to unpick what's going on for a young person. And what I'm finding with that and my own direct advocacy with children and young people is that often social workers and advocates, but equally social workers, don't understand the difference between DOLS and a deprivation of liberty and authorising something through the Court of Protection and authorising something in
I've lost sound off Emma. Can you hear Alice?
No,
No.
frozen them.
I'm so sorry, Emma. We've lost your sound. Did you want to pick up on any of that theme, Alice, of kind of lack of understanding and misuse perhaps of legal process?
Yeah, I think it's a huge issue in this area. And we published something when we kind of started doing our research in this area that I'll post in the chat, but tried to kind of clarify the legislation around deprivation of liberty order. What is a deprivation of liberty order? When should you seek court authorization for a deprivation of liberty order? But I think it's something when we speak to children's services managers and local authorities, to lawyers working in local authorities, they I think it is poorly understood, and I think that does lead to kind of misuse of I think I guess our biggest concern is where a child is being deprived of their liberty and there isn't any court authorization, whether that be under the Court of Protection or the inherent jurisdiction. We have seen, so the inherent jurisdiction would tend to be used mostly for children in the care system, so children who are subject to care orders or in kind of voluntary care arrangements. And in some cases where it's thought likely that their care needs are such that they will be referred to the Court of Protection, we do see the High Court of the Family Division, so the court making the inherent jurisdiction cases, referring those cases into the Court of Protection, so they can start to be heard there. But I think there isn't any kind of clear-cut guidance about when that should happen, exactly which court local authorities should be applying to. Hopefully more guidance will come on that. But yeah, I think if there is concern about a deprivation of liberty, any court authorization is better than none.
Thanks, Emma. And Tom, nice to see you, Tom.
It's great to join you. Thank you for putting on this excellent webinar, which touched upon many themes I'd like to have picked up at your conference last November. Unfortunately, I broke my leg and couldn't attend then. But the article I read for the magazine that you issued for that conference is relevant to this, and I hope you can reshare it. I've got two questions. One, to follow up the stuff I put in chat with Emma. Emma's analysis is spot on, so I'm going to agree with that for spot on. It's a challenge to you, Kate. I believe there are hundreds of advocates who are very competent but aren't prepared to take a stand on this in terms of independency and lack of accountability, because it's very difficult to bite the hand that feeds you, especially in some organizations. So I'd like to hear how you believe you can gather a group of advocates. Not all of it, not everyone wants to do this, and I get that. I'm not saying everybody should, but to come together to make a stand on this collectively, to challenge the lack of accountability, the lack of inherent injustice, which is hardwired into the family court system. So it's a challenge to you, Kate. how to do that is difficult, but it's response to Emma's point there. The second point to you, Alice, excellent analysis. I'm just going to pick up one point in which I disagree with you, but there's lots which was very helpful and constructive. It's the omission of families from the support plan which you put together. I'm not saying all families. Some families are maybe very damaging and hurtful and etc., but some aren't. Some have been slapped, or especially single mothers have been slapped with the label of neglect, when they have to deal and cope with great difficulties of poverty and trauma themselves. I know that. And with the fraction of the money that professionals are given in hundreds and thousands of pounds, barrel loads of dosh, let's call it, if they were given a fraction of that and supported effectively, they can be part of this supported plan. And the children and young people, A, may not need to go into care in the first place, or B, could be supported much better if they were put temporarily into care.
Shall I come in first, Kate, and then I'll pass over to you? No, I completely agree, Tom. And it's omitted from our kind of 5 headlines and maybe the kind of longer description I included, but it is something that's very much included in the longer version. And perhaps we need to make that clearer. But yeah, 100%. I think we've seen parents are not involved in these cases. This is often younger children who want to return home to their families, who have strong relationships with their family members, and we're really call for greater involvement of family members in these cases, as well as much more longer term support kind of early on when there are issues in the family home that are called to the attention of children's services. We know that often the support that can really keep families together, keep children at home is just not provided, and that can lead in the longer term to these children being deprived of their liberty. So no, completely agree with you, and sorry that didn't come across in my presentation.
Thank you, Alice, for your answer. Just put it into your charts because it's spot on. Thank you.
Thanks, Alice. And there's no way I can possibly answer your question to me, Tom, in 20 seconds. But I think there's a lot of advocates probably on this call who feel frustrated with how safe advocacy has become, how short-term, issue-based, a bit tick-boxy. I think there's a lot of advocates feeling like that. Tomorrow, as Emma has mentioned in the chat box, we have a webinar specifically looking at political activism and how advocacy, needs to get back, in a sense, to more radical and campaigning and systemic issues. So yeah, please, if you would like to join us on that, and that's why we have the black belt advocacy, which is all about being brave. It's all about being brave and taking a stand. Yeah. I'm conscious we've now hit 3 o'clock. June has done a shout out for the Potato Group conference. June, I'd be very happy to circulate details of that. I think I'm also going to circulate a very helpful briefing paper from Alex Keane and 39 Essex Street, because they did a marvellous piece on the difference between DOLS for children. You were right, Emma, to distinguish DOLS to deprivations of liberty, and then also for 18 for adults. So I'll circulate that. But it feels as if we need to come together again to talk about this from a practice. So shout louder, be brave, love it, Kim. Let's kind of keep in touch with this. I'll wrap up and thank Alice. Maybe we can show our appreciation to Alice, because it's definitely helped, I think, a lot of us, and if nothing more, to realise that as advocates we need to be getting involved in every chat. I mean, there's so many children in care, isn't there, Alice, who are having these. All of those children should have an advocate. They should. All of them should have an advocate. So yeah, let's keep this on our hot list. It's lovely to see everyone, and hopefully I'll see you tomorrow. If you want to drop me an email, I can send you the link. Take care. Oh, Alice, did you want to say any final words? I should offer the speaker the final.
Thank you.
No, just to thank everyone for coming. I hope you found it informative. And great.
Thank you, Alice. It was brilliant. Really good. Thank you.
Right. Thank you.
Thank you.
Bye.
Bye.
Thank you. Bye.
Thank you.
Bye.
And thanks, Ross. That was a long session.
You're welcome, Kate. Fascinating.
Thank you.
Thank you, Alice. Have a nice evening. Take care, everybody.
Thanks. Bye.
I'll be in touch, Ross. Yeah, thanks.
And yeah, thanks, Kate. That was yeah, I hope that was useful.
Oh,
for you.
absolutely. Let me just stop recording.